right. Well, thank you very much, and thank you for having us here today. Um, the global privacy patchwork has created significant challenges for participants that we all work with in the digital advertising industry. And that's because technology is complicated. The partners we work with are often many, and the slightest variations in the different privacy laws can result in cascading legal and data management efforts in organizations. So today, we're going to cover how the proliferation of different privacy laws and enforcement approaches in the states, in Washington, D.C., and globally create a challenge for the digital advertising industry and how companies can best manage their compliance. On a local level, we're seeing how the confluence of CCPA, CPRA, VCDPA, and CPA each contain important differences in the scope of opt-outs, which is something that the industry is trying to grapple with now, and in particular in some of the working groups that we're involved in and leading at the IAB. With us today, we're going to talk with Jessica Lee, who is the chair of Loeb & Loeb's privacy practice, about these state-level privacy laws. And also, in the absence of a federal privacy law, all eyes now seem to be focused on the FTC. And today we are joined by Jessica Rich of counsel with Kelly Dryer Warren to discuss the federal landscape. And Jessica previously served as a director of the Federal Trade Commission's Bureau of Consumer Protection. And overseas, we're going to talk with Mark Weber, who's a partner with Field Fisher, and he's going to be able to speak to what is the first big patch in the privacy quilt, which is GDPR, and how that's now being applied to the digital advertising industry. And then finally, we're going to focus on the cascading impact of GDPR in other countries. And we're going to focus on Australia in particular, where that country just started its process to amend its national privacy law. And we will be joined by Sophie Dawson, who is a partner at Bird & Bird's Australia office, to discuss. Then we're going to pull it all together, and we're going to do a roundtable with this terrific group of experts to talk about the common issues and common challenges in the patchwork. So with that, let's get started. Jessica, good afternoon.
Hi, Michael.
So let's start with this patchwork and the challenges that are involved in CCPA and soon to be CPRA, VCDPA, and CPA. So what's different about these laws in these between each other, and how do they pose a compliance challenge for the clients you represent?
Sure. Well, and like everything, I think the devil is in the details, and specifically for these laws, in most cases, in the definitions. So just kind of big picture, the bones of the laws are somewhat similar with respect to giving consumers a certain baseline of rights, right to access, right to know, delete, we have portability. We're seeing between CPRA and Colorado and Virginia, the gap between the CCPA and the GDPR closing with respect to broadening the additional rights, correction, deletion, et cetera. So you have kind of a baseline there. Then you have some similar business obligations. Again, looking a little bit to GDPR, pulling in concepts like purpose limitation and data minimization. So broad strokes, these laws have a lot in common. But when you get to the weeds, as companies are wont to do, and particularly in this space where data is so important, they don't quite exactly overlap. So there are exemptions that are broader in certain places. So for example, in Colorado exempts data covered by COPPA. So if you deal in children's data, that becomes quite important. There's exemptions in Colorado for internal research. It's kind of digging into, well, we have this broad pool of data. I know a lot of the participants on this call are focused on advertising, but how there are so many different data streams, and parsing out each category of data, how it's impacted by the law, and each data use, I think is where some of these exemptions come into play. Even things like the deletion exemptions aren't exactly the same. We really have to go in line by line and understand, well, when do we have an obligation to delete? And that impacts how you operationalize the deletion obligation. We look at things like, we have selling, we have sharing, we have opting out of cross-contextual advertising, of targeted advertising, matching those up and figuring out, well, what does that mean and what are the commonalities? Can we create some commonalities? We can have a common approach. All of that becomes a challenge. So it's really getting into the weeds of what these laws require. And of course, one of the bigger pieces that's gotten a lot of attention is the requirement to opt in for the use of sensitive information in Virginia and Colorado. So there's this patchwork gives a foundation that you can build on. But I think for a lot of companies, it's figuring out, well, what does this mean in practice? And once I get into the weeds of this law, what does it mean for the business and how we operationalize?
Yeah, and one of the interesting things, which I think is an incredible challenge from what you just said there, when you mentioned the difference in some of the scope of the language around opt-out. I look at CCPA and CPRA, which provide an opt-out of selling and an opt-out of sharing. And then you look at, Colorado or Virginia's privacy law, and it's really not an opt-out of the disclosure. It's an opt-out of the processing of personal information that's used for a particular type of purpose, which is a very different type of thing, which inevitably has a very different scope and a very different data management component. Are you beginning to see your clients begin to plan around that? Or is this a little bit similar to like this early period in CCPA where everyone sort of threw their hands up in the air for a little while and until they finally figured out a way to go?
I think because we're coming up on the end of the year, and we'll be heading into the sprint that will be 2022 to get to the end of 23 and all of the compliance. I think companies are starting to wrap their minds around it. I think earlier this year there was a thought of, let's see what happens. We know for CPRA there'll be regulations. We might see some additional guidance coming out of Virginia and Colorado, but I think you have to kind of face the fire with respect to the scope. And you're exactly right. For all of the talk about the impact of CCPA and now CPRA, it really is about opting out of the sharing with third parties for certain contexts, as opposed to this opting out of a certain type of processing activity that can include your kind of internal business use. And I don't think that companies have necessarily started to measure the impact of that and to start to really come out with processes for handling it. So I think that's going to be a lot of the work of the first part of 2022. Like I said, it's starting now, but I think that's a lot of the work of the first part of 2022. I know there's always a lot of hope, as you know, and pressure on the industry groups to save the day and help come up with in that regard.
I have some sense of what you're talking about. So let's move to sensitive personal information, which is something that you just touched upon. And so can you talk a little bit about how sensitive personal information is treated under these different regimes and how that could have a cascading compliance impact?
Sure. So for CPRA, in addition to the ability to opt out of the sell or sharing of information for cross-contextual advertising, you also have the ability to limit the use of your sensitive personal information. And what this means is that if you're on a website, call it WebMD or some other site where you might be, it doesn't even have to be a medical site, for example, you could be collecting, racial and demographic information is included in this definition. There's precise geolocation information included in this definition. You're able to opt out of having that used for any purpose other than the purpose for which it was collected. So I go on a website and I fill out maybe a combination of health and demographics for a skincare quiz, for example. It can only be used for that purpose. Whereas now a lot of that information, one of the goals of collecting it is to use it for additional purposes to understand who's on the site, to serve targeted advertising. And so there's the ability to limit the use of that information. If we look now to Colorado and Virginia, now that that standard is much higher because it's an opt-in requirement. It's not as prescriptive in terms of what that opt-in looks like, but opt-in versus opt-out, as anyone on this call I'm sure is aware, very, very different standards, much higher bar. And for a lot of companies, it's going to be figuring out, well, first, what is the scope of personal information that I'm collecting? How am I using it? And then what kind of mechanisms am I going to put in place for both this opt-in and opt-out? And how am I going to track it? From a data management perspective internally, how will I have this information tagged so that all the rights are applied to it appropriately? And I think that's in general with this kind of patchwork approach, particularly in some place like the US where, we're talking about 50 different states, many times not understanding where your consumer is coming from. How do we tag these rights appropriately?
So, looking forward into 2022, one of the big things we're focused on in the IAB Legal Affairs Council is how do we come up with an industry framework that can in some way create an industry level compliance mechanism that helps companies address compliance across multiple privacy regimes covering the different states. And you have a somewhat different challenge in when you're counseling clients in this area, because you're not focused so much at the industry level, but you're looking at their individual efforts. If there's one piece of advice that you're going to give to your clients who have to come up with this multi-state approach to compliance, what is it?
I mean, number one, map your data, right? And mapping means different things in different companies, but we saw this starting to happen when companies got ready for GDPR, and some said, well, we're just going to deal with our EU data. And then California came, and if you could do California, maybe you just did that. But at this point, companies really need to have a sense of what they have, where it sits, what they're doing with it, and understand kind of the business impact associated with that data. Because like I said, like I started this process off with, I do think there is a foundation that you can build for these, and I think that foundation will help for any future state laws. Again, you're going to see a baseline of consumer rights, you're going to see a baseline of business obligations, and you should be able to build a program out that manages that. And where you're going to get into more of the detail is everything on top of that. So where you do have to opt in for certain types of data, where you do have restrictions on selling and sharing, you're going to have to layer on top of that. And understanding the real business impact, I think, will help companies decide what to do. For some, they're set up in a way where you could just take the highest watermark, and because that's easiest from a compliance perspective, that will work. There are others who the value of the data and the value of the revenue generated from these advertising activities is so high that it's worth it to put a process in place that's more patchwork and really applies these rights on a kind of state by state basis. And that really is going to depend on where you sit. I think we're going to get to a place where it's across the board, but I think companies have to make a real business call, and maybe like we saw with CCPA, there'll be the phase one of we're going to sort of grit our teeth and see what happens, and then sort of easing into the reality of what these new laws kind of pose for us.
Well, we could spend an hour talking about this stuff. So take us out and ease us into reality as it relates to global privacy control, because it got a lot of attention when the former Attorney General tweeted about it. And we saw enforcement actions publicly announced, or some of their enforcement actions were publicly released that related to GPC, and so that is obviously an area of priority in California. The references to it in, I believe, the Colorado privacy law. What do you think the GPC landscape looks like? I mean, it says it's global, but right now it's only in one state. And how do you think that's going to play out over time?
Well, it's good. So first of all, on the global piece, I don't think it is global. I think global in this context doesn't mean global in terms of geography. I think it means global across all of the websites accessible via that particular browser. And I think we already saw some feedback. I think the ICO in their recent guidance about ad tech kind of came out and said the GPC doesn't really work for opting out of processing there. So I know that's where they want to go, but I think this is really kind of a US tool for right now. And I'm sorry, I don't know if I'm going to be easing anyone into anything, but I think that GPC is here to stay. Unfortunately, I think how it gets kind of nailed out in the weeds, we'll have to wait and see. But with Ashkan Soltani taking over CPPA, there's very little chance you're not going to have to comply with GPC in California. It's in the law in Colorado. And if they make it a requirement for browsers to offer a global privacy control, I think it's going to be nearly impossible to really have it limited to these two states. Like that's just not how the web works, right? This is going to be something that's available. And I think you have regulatory push for this as well. The idea that consumers should not have to go website by website, and have to effectuate their choices. So I think we're going to have to balance what happens, in the business end. The argument is, well, I have a personal relationship with my consumer. I want, the consumer to be able to make choices about how they interact with me. I want to be able to give them incentives. I want to build trust. And I think we're going to have to see that tension balance out, but in some shape or form, I suspect GPC is here to stay. So that's not easing us out anyway, but that's my perspective on what I think will happen.
Well, you're helping us all get ready. Thank you very much, Jessica. So let's turn to Jessica Rich. So we heard that the patchwork of state laws with their differing standards creates a compliance challenge for the digital advertising industry. And for the past several years, we've heard so much about the possibility of a federal privacy law, and in particular with preemption. Where do those efforts stand today?
Well, thank you for having me, first of all, and for being here with this great group of people. Well, there have been many bills proposed, circulated in the last couple of years, actually the last over 20 years. And I've been involved the whole time, hoping on hope a privacy law passes, and it never does. Just to name a few: Cantwell, Wicker, Wyden, Eshoo, Del Bene. Most recently, the House Republicans from the Commerce Committee circulated a draft. So they haven't passed. As to preemption, many of the Republican bills have broad preemption provisions. The Democratic bills are more mixed. Some of them have preemption, but it's often things like preempting laws that conflict the state versus the federal law, or even preempting laws that conflict, but then preserving state laws that are more protective than the federal law, which doesn't help people who are trying to navigate multiple laws. I personally think, I've been following this for years, I think there's a deal to be had on this issue, including on preemption, if the privacy law is otherwise strong and the attorney generals can fully enforce it. I've actually talked to some assistant AGs who think that would be a perfectly fine scheme. But there are other issues that divide the parties, including private right of action, which I think is more intractable for a lot of people than preemption. At this point, no federal bill has made it very far. Also, the recent focus has sort of veered more towards competition, platforms, content moderation. There's a hearing in the House this Thursday at which I'm testifying, and I thought it was going to be about privacy, and it's all about those other issues. So if industry wants a federal law with preemption, it needs to do some real work to get Congress to act on it.
Well, that's great advice, and with federal privacy legislation not happening tomorrow for sure, all eyes now seem to be on the FTC. And so could you give us a state of play of what's been happening at the FTC and how you think that's going to impact the digital advertising industry?
Well, I think it's safe to say that at least some people at the current FTC don't appear to be fans of personalized digital advertising. They're calling it surveillance advertising or commercial surveillance, and they talk about reining it in. The FTC has several tools it can use to ramp up enforcement in this area. It can enforce the law against unfair and deceptive practices, and it's been doing that. But this commission may take a very aggressive view about what's unfair and what's deceptive. They may try to require choice wherever possible, or limit certain types of digital advertising, for example, involving sensitive information. The FTC can do industry-wide studies and reports. It's done that for broadband providers, data brokers, social media companies, many other examples. And it can issue new rules under the FTC Act, even if they're not mandated by Congress. That's under its so-called MAG-MOS authority, which, as I'll mention in a moment, is extremely cumbersome. So these tools give the FTC a lot of latitude, but there are some real hurdles too. Contrary to what is often thrown around when people are just discussing deception and unfairness, those standards require the FTC to meet certain elements that are of proof. Deception has to be material. Unfairness, you have to show a likelihood of significant injury, and you have to satisfy a cost-benefit analysis. Also, the rulemaking, Magnuson-Moss rulemaking, is extremely cumbersome. And without getting into, I'm happy to answer later what kind of steps need to be taken under MAG-MOS, but those rules take years to complete, and it's really not going to be feasible to do any kind of broad rule under MAG-MOS. Now, as you know, the FTC in the Build Back Better reconciliation bill, the FTC gets $500 million if that stays in the bill, and it may even get penalties for Section 5 violations, although that's much less likely. So if that happens, the FTC may be willing to take on some of these challenges. So the industry may have some things to contend with in the near future.
In October, Commissioner Slaughter provided remarks where she questioned whether the notice and consent framework that most companies use, whether that works, suggested that a data minimization approach is better and that it won't, quote unquote, break the internet because there's the alternative of contextual advertising. Is that a widely held view in the FTC?
My guess is it's shared by Chair Khan, given her discussions about surveillance and her references to surveillance and reining it in. I'm sure the Republicans will view most personalized advertising as legitimate. And I don't know where Bedoya will be if he gets through his nomination, his confirmation hurdles. But it's really important to remember a few things. Concept of data minimization isn't new, and the context and criticizing notice and choice is not new. This is stuff that's been talked about for years, and data minimization is a best practice. It can be an element of a data security violation under FTC precedent. It's already in COPPA, it's in the CCPA, it's in GDPR, it's in many federal and state privacy proposals. So that part isn't new. While it is a particularly difficult concept for the ad industry, which is all about using data in various ways, but the ad industry can work on parallel protections as to use and sharing. And I know it is, because I've helped work on those with people in the ad industry, preventing use of data for secondary and potentially harmful purposes as data travels through the chain. That's something that your industry should be working on very hard. The other thing, this is a speech that one commissioner is giving. It's not a rule or a case that could be challenged in court. She's trying to create some sizzle, and I guess she did. As I said earlier, the FTC will have enormous hurdles if it tries to impose broad bans on personalized advertising and content. I doubt they'll try. They may try to do something narrower with relation to sensitive information.
Maybe you could take us out on a note about what is your prediction about what the FTC is going to do around privacy and digital advertising?
Well, I don't expect, unless they're nuts, I really don't expect the FTC to try to do a broad privacy rule with hundreds of mandates in it under its own Magnuson-Moss authority. But I do think they're going to bring aggressive enforcement and maybe launch some narrower rulemakings around what they're calling surveillance, but it'll be limited to certain types of personalized advertising, dark patterns, maybe teens, health, issues involving sensitive data where there's a little more consensus and where there's stronger law on imposing limits. As to the surveillance issue, this may be news, or you guys may all know this. It's rumored that a rule was actually written this summer on surveillance. I heard this from a reporter. And Chopra voted on it before he left, one of his zombie votes. It was pulled because it was not well done. So I think the FTC is going to try again on some form of surveillance rule once Bedoya gets there. I don't think it'll be some sort of broad ban, because that would be just completely not upheld in court, but it'll be narrower. And there'll be enforcement on all of these things. And again, if the FTC gets the 50 million and penalty authority, you should expect a very bumpy ride, at least until somebody pushes back in a lawsuit.
All right. Well, thank you for that, Jessica. And now we're going to move to take a look at what is happening in Europe with GDPR and where the patchwork all began. Mark, why don't you join us in this dialogue? So, to some extent, the arrival of GDPR made everyone think real hard about lawful digital advertising. Notably, the interplay between e-privacy laws and GDPR was all important. What did you wake up to in May of 2018?
Well, yes, thank you, Michael. What did we wake up to? In some ways, we woke up to it in December of 2016 when the GDPR came out, and we all had to run hard, ready for May 2018. But it was definitely an awakening. Part for ad tech, because ad tech had grown fast, not necessarily with privacy in mind, and certainly not necessarily with European privacy in mind or the GDPR. There are a lot of businesses at the heart of ad tech which were US or non-European centric. So the GDPR was that awakening, partly because the prospect of large fines, 2% or 4% of global turnover, that began to make some think about it. But the GDPR really asked everybody to look inward at what data they had and why they had it. Because the ad tech ecosystem relied on so much collection and so much processing of data, and then shared it amongst multiple parties, they were very much at the forefront. At the forefront, that wasn't an accident. The GDPR had done a couple of things really to bring ad tech within its sights. First of all, many ad tech providers consider themselves processors. So acting on behalf of somebody else, the GDPR kind of turned some of those interpretations around and actually put law in place in relation to a processor for the first time. In the same way, many of those organizations considered they were outside of the scope of the jurisdiction of the GDPR, but GDPR, with its Article 3.2, effectively had extraterritorial effect. The business in San Francisco doing ad tech was now within, or at least conceivably within the bounds of European law. So suddenly US businesses had to sort of look at the ecosystem on what they were doing in Europe. The GDPR also made it clear what personal data was. We sort of already knew it from our European legislation, but just those emphasis around direct identifiers, but also those indirect identifiers, making it things like cookies, device IDs, IP addresses, and other identifiers were personal data and were caught. And then also, the ad tech industry lost that kind of, we're not processing personal data anyway kind of argument. So there were a lot of changes, coming to the fore, and GDPR regulated the processing of personal data. So suddenly that collection, that use, the disclosure, the dissemination, and the general sort of uses of data now required that ad tech processing was fair, lawful, and transparent, and a new, a real new sort of concept to think about. And in particular, it was difficult because there was already other law in place in Europe, and that's the e-privacy, which you were mentioning. So when you're thinking about ad tech, you're thinking about two things: the collection of data, how do you come across it in the first place, and then the use of that data. So e-privacy generally impacts the collection of that data. It's essentially the rules that the cookie laws, they're the rules that lead to all of these cookie banners that we see. And the new focus on e-privacy was important, partly because businesses were looking at privacy in another way, but partly because the GDPR changed the interpretation of some of those e-privacy rules. So e-privacy regulates the storing or gaining of access to data on an end user's device. Essentially, if you're going to grab a cookie off a device, you're gaining access. If you're going to store that data on their end user device, you're storing data. The e-privacy rules, which have been around since 2002, updated in 2009, now required already prior informed consent for the storing or gaining of that access. GDPR came along and said, hey, consent's going to change. We've got a new definition of consent. So if you're placing a cookie or gaining access to that cookie, you need consent under e-privacy. Well, GDPR said that consent means freely given, specific, informed, and an unambiguous indication of wishes. A very precise definition really meant the opt-in, all the difficulties that Jessica was alluding to in the US world. Opt-in was something that's really quite difficult to do. So ad tech was facing new look at e-privacy and the way they collected information, and then GDPR, which came and said, well, to the extent you're processing that data, you've got to process that in accordance with the law, and there are other rules then. So there's the obtaining of the information and then using of data, and looking at how you do that across two fairly complicated sets of rules. Now, with GDPR, everybody looking at that, at the same time, somewhat unfortunately, Europe had announced, well, e-privacy, it's been around since 2002, we're going to reform that, and some rules are coming soon. So some took the view, well, I'll sort that out when I know what those new rules are. Of course, we still don't know what those new rules are under e-privacy, and we're operating under a very, very complicated patchwork of two complicated pieces of legislation with a lot of data and a lot of collection and use and sharing, Michael. So what we do know is we need transparency and clear, open and honest use around data, and the way data is collected, the way it's used, and then the way it's shared. And that's really what we've been struggling with in Europe ever since.
Well, let's talk about regulation and or enforcement of the law. And that's certainly an area that has been the focus of attention in the ad tech community as we have followed this closely since implementation. And, we were also intensely focused and engaged, for example, with the UK ICO's industry investigation as well. So I was wondering if you could give us a picture of, what the case law has taught us, what we've learned from regulatory enforcement and investigations.
Yeah, sure. And we've learned quite a bit, actually. Let's take the guidance that's come out from the regulators first. They have spent quite a lot of time teaching us what good cookie use amounts to. So actually being more prescriptive about how you're going to use cookies, what kind of notice you need to put in place, how that notice needs to be presented within a banner, the fact that you have to give as much focus to opting out of the cookies and all cookies as you can to opt in, and not using some of these dark acts and trickery to kind of manipulate the outcomes. So there's been a plethora of that. The problem with that law is a lot of that has been local guidance. So although there's some, a lot of commonality, there's a French view which gives a slight twist around analytics cookies. There's a UK view now, obviously outside of Europe because of Brexit. And only last week, Germany have only just caught up and implemented some of their e-privacy laws, getting on for 10 years too late. And they had a very different view around opt-out and opt-in. So for any business looking at all of Europe, they've been forced to look at new and relatively, difficult to interpret law, and then a patchwork of new laws where actually you're beginning to see different, potential outcomes from the regulators. But we have seen some guidance there, and I think we're in a better state, and individual businesses have been in a better position to enhance their notices and their collection practices around that. Right now, we're seeing the regulators get on top of that. Letters coming out from ICO, letters coming out from the CNIL, the French regulator, and a bit of emphasis and bringing attention to certain players around the way their cookie use has taken place. So quite a lot on the guidance side of things, but more to come, I'm sure. And GDPR and e-privacy issues continue to haunt us, particularly with the proposed reforms around e-privacy. On the case law side, Michael, there has been some insight. Now, some of that insight has come as a result of interpretations of the law prior to GDPR, but that's been very helpful to us because the law prior to GDPR in some areas, is very relevant. And I guess 3 or 4 cases come to mind. First of all, there's the fan pages case, which is a Wirtschaften case. Basically, an organization running a fan page, your own sort of homepage on a Facebook, is now seen as a joint controller. Somebody who's jointly responsible alongside Facebook for the collection of data via that fan page. Historically, we always thought, well, the fan page is on Facebook, that's Facebook's problem. Now we're told, well, you take the view you're going to build a fan page. The fact you've got that fan page allows Facebook to collect data, and therefore you're jointly responsible alongside Facebook for that collection. And that's the beginning of this concept of joint controllership and of joint responsibility we're seeing. So changes to your contractual arrangements, changes to your notice, and then some important analysis around, well, who's responsible for rights, who's responsible for that notice, and what happens if an individual wants to exercise those rights. So fan pages, very, very important as an early piece of case law. Then fashion ID, again, looking at coming from the CJEU on GDPR. Joint controllership, again, was focused upon. In that case, in the sense of website publishers that are using social plugins, so the like button or the share on LinkedIn, those buttons also collect data. But what the CJEU, Europe's highest court, made clear that is, if you're going to run a website as a publisher, you're going to use a third party with a plugin, you're jointly responsible alongside that third party for the collection, because but for your election to put their plugin on your website, the data wouldn't be collected. So again, seeing some responsibility. To a degree, that's made it easier for the publishers out there because they've actually got leverage against some of those platforms, but they are side by side joint controllers and jointly responsible. So that concept of joint controllership coming in again. And then Planet 49, which is another CJEU case, would be the third one to highlight. Again, around a CJEU, a lottery being run online and clicking through to participate. In this situation, it was really focusing on what consent amounted to. Now, on this lottery online page, the cookie acceptance was pre-checked. Essentially, we were looking at whether or not a pre-checked box would be enough. Now, the GDPR already said a pre-checked box wouldn't be enough. And the CJEU said active consent is required for advertising and cookies, and declining to deselect a pre-checked box wasn't going to be enough. So we had more confirmation that you needed a clear affirmation, a clear consent, and cookies were key. So changes to the CMPs and the cookie banners we were seeing as a result of that. All focusing in on the fact that it's important to be transparent. It's important to look at who you're working with, what other technologies are alongside you, and the fact there might be some joint responsibility, and then focusing in on back to this notion of opt-in or essentially consent and what consent amounts to, and pointing out that it's a very high standard and you've got to make clear what you're collecting, and you can only then build trust and use that data if it's been very clear from the very beginning how you're collecting that data. And we come back again and again to the way that data is collected. In some ways, we're likely to see more, particularly around some rights of private, some of the private actions and things we're taking away, the way that data is used and shared. And I suspect in the next year or so, we're going to see far more focus moving away from how data is collected, but then how it's used within the ad tech ecosystem. So.
Well, thanks for those terrific insights, and we're gonna bring in Sophie now to the discussion to talk about how GDPR is impacting the global landscape. And you know, one of the things that I've certainly noticed in my role at IAB and having pursued some global projects, including our cross-jurisdiction privacy project, where I had the pleasure of working with Sophie, was how many jurisdictions were GDPR inspired, but actually the substance of it didn't really look exactly like GDPR in many respects. And so, you know, you're in a unique spot now in Australia because there are two privacy reform processes that are underway presently. Can you tell us a little bit about them?
Sure, Michael. Yes, you're exactly right that we've got our very own privacy laws, which are not exactly like anybody else's. So our piece of the patchwork quilt is very much our own. It's under review in two different ways at the moment. We've got an exposure draft bill that's been released, and submissions were actually due on Monday, but I think a lot of people have extensions and are doing them now. But which would bring in a power for our privacy commissioner to essentially put in place a code with quite specific rules applicable to social media, large digital platforms, and also data brokerage services. We also have a broader privacy review process, and submissions on that are due in January. And I think that the Australian story picks up on the global themes we've heard today, which are firstly that it comes very much from a competition as well as a privacy focus. The current reforms stem from a digital platforms inquiry report done by our competition regulator, which was instigated in 2017. So it's been quite a long conversation in Australia. And flowing from that process, we see proposed privacy reforms and also sort of consumer protection reforms in the ad tech space focused on transferability and promoting competition. So in the privacy space, we're also seeing the same themes we've heard from Jessica and from Mark, both Jessicas and from Mark, which is that there's a focus on notice and consent, but there's also a concern that that may no longer be the appropriate approach, and our regulators are talking about, well, maybe we should move to more of a focus on what's fair and reasonable from the regulator's perspective rather than it being all about consumer control. So I might just pause for a second and talk about which bits of each of those changes is most relevant to ad tech. But before doing so, I'd also note that the enforcement theme we've heard both from Jessica Rich and from Mark is true in Australia too. Both our privacy commissioner and our competition regulator are really now taking the gloves off, and they're not shy of big litigation to enforce both the privacy and the competition laws.
So, well, let's dovetail back into what you alluded to, which is what's really important to ad tech in all of these changes. You know, I tend to think that ad tech touches on so many of them, whether it's individual rights or you know, opt-in, opt-out regimes, because you know, ad tech is the engine behind the publisher and advertiser relationships. Take us into that. What's important to them?
Well, there's quite a lot that's important. So I'll take first the exposure draft bill. The government's talking about bringing that in quite quickly. And what that would do is it would do three things. Firstly, it would increase the penalties for serious and repeated breaches of privacy or interferences with privacy. That's been on the cards for a long time. It will increase the maximum penalty to 10 million Australian dollars or 10% of annual revenue or the benefit received, whatever is the greater. It will also extend the extraterritorial operation of the Australian Act, so it will no longer be confined by reference to Australian sources of data. And then thirdly, and most importantly from an ad tech perspective, in the areas of social media, large digital platforms and data brokerage services, which can, and those definitions can catch a wide variety of players in the ad tech industry. It empowers the Privacy Commissioner to make a code, and it requires that that code does things like introduces the requirements that Mark's talked about from the GDPR in relation to the currency specificity and informed nature of consents. So it could have a real impact on the current practices in relation to consents, including it's common in Australia for there to be bundled consents, and there may be a requirement for them to be unbundled. The contemplated code would also enable individuals to request that their data no longer be used or disclosed. Now, that's not an existing right in our Privacy Act. So the code would substitute for existing privacy rules, the Australian privacy principle in relation to those entities that are caught, and it could really leapfrog the more general reforms in that it could very quickly bring in some of the reforms that have been contemplated as part of longer term change in Australia. So this code proposal, which is currently in play, is very significant. In relation to the bigger reform process, which is contemplated to be longer term in nature, there are a lot of changes which are very relevant to ad tech. They include changes to the personal information definition, contemplating picking up on the GDPR definitions, which pick up on technical information, which is sometimes relied on in the ad tech world to say that data is anonymous and not regulated. So it's quite likely that that will more squarely bring some data within the ambit of our privacy laws. There are also requirements around consent. There's the idea of people being able to elect essentially to notify organisations that they may no longer use or disclose information for their information for ad tech, for direct marketing purposes. So there are also potential changes around notice and consent, which would require a lot more consent and a lot more notice a lot more often. But there is a recognition, there's a bit of a tension there, because there's a recognition that part of the GDPR feedback has been sort of consent and notice fatigue. And so the review is also looking at possibilities such as requiring participants in the ad tech environment with large data sets to assess privacy risks and manage them. So a sort of holistic duty of care type approach, and also the possibility of a rule saying essentially that they must ensure that collections, uses and disclosures are fair and reasonable. So again, it's a sort of different approach to privacy regulation, and that's on the table as well. So submissions on that are due in January, and I think there'll be a lot that will be said about those different possible approaches. And as I think it was Jessica said at the beginning of this call, it's so important that people map their data, understand what their uses and disclosures are, and understand not only the impact of these potential changes in terms of their practices, but also for their systems and software, so that really, they can be informing the government to make sure that there are appropriate lead times and approaches to these issues.
So I have two questions. I'm gonna bundle them together, and one of them is actually going to be about bundling. So where do you think you're going to end up with a revised privacy law in Australia vis-a-vis GDPR? And in relation to that, when I think about bundled consent, which also gets a bad name, you have at one extreme, you have the transparency and consent framework, which is designed to comply with GDPR, which breaks down consent into the finest, narrowest forms possible, which is itself a challenge to companies, and it's a challenge to consumers. And one of the things, for example, that we did in the cross-jurisdiction privacy project is we said, Well, we're going to look across a dozen jurisdictions, and if they don't require that very finely grained consent, which is often just very difficult to digest in and of itself, can we come up with more logical groupings that are more accessible to consumers, which is a different approach from GDPR? Where do you think Australia is going to end up generally, and then specifically as to that issue?
Well, I think that's an excellent question, and it's one that's explicitly raised in the current reform process. So essentially, the paper, the discussion paper on which comments are sought, says, look, there's this tension between these specific consents and notices, and essentially other modes of giving people more control. It raises as one possibility as an alternative to having a privacy default, which is privacy protective, sort of essentially have an opt-out default and require people to opt in. It says, well, one alternative would be to require some sort of privacy portal where people can control the privacy practices holistically. And that's obviously quite a sensible idea. If you had a portal and you advertised it so that people knew where to find it, that may actually be easier for consumers to handle than being bombarded with constant questions about what they want to do in relation to privacy. But essentially, it's all in play at the moment, and we don't know precisely where it's going to land. And I think that the government's going to be very influenced by essentially what's going to best protect consumers. In Australia too, there's an overlay that we have. Section 18 of our Australian consumer law says that you can't engage in conduct which is misleading or deceptive, and the competition regulator has used that to take action in relation to privacy notices and consents which they think are misleading. So it is really important when you're dealing with an Australian notice or consent to actually step back from the privacy requirements and think, does this make sense to a consumer? Are we telling them what they need to know? Is there a competition risk in addition to, is there a privacy risk?
All right. Well, thank you, Sophie. Let's bring everyone in together and see if we can cover a few big picture questions with the time that we have left. So one of the things that we saw with CCPA was that a number of publishers nationalized those CCPA rights into other states, and they did it typically for two reasons. It was either just simpler to have one common approach, and second, it didn't put them in a position of treating users differently. And likewise in Australia, my understanding is that many international companies deploy GDPR rights just as a simple mechanism or a simpler mechanism than pursuing a bifurcated approach. What do you all think the future holds for these attempts to engage consumers in a way that nationalizes rights or tries to globalize rights, whether it's CCPA or GDPR or something else in the pipeline? Is that going to be under pressure now?
Well, when you say under pressure, do you mean pressure for the businesses to take that approach, to do that nationalization?
Well, I mean, is it going to be possible, even from a legal standpoint? There's certainly a business desire to come up with a single framework. And so, for example, a company that goes into Australia and says right now that I'm going to use my GDPR approach in the Australian market, by and large, I'm going to take a guess that, they're probably on the right side of the law, even if it's not particularly designed for it. But that might not be the case. It might not be the right fit. Could be square peg, round hole when it's all said and done. So that's the challenge I'm trying to see if you think is going to exist, whether that approach is going to be viable.
I think it's going to be really hard, to be honest. And I think there are also cultural differences in how these practices are viewed in different places. And so I think you have to deal with that layered on top of the kind of compliance and does it, comply with the law across the board. I think you might get to a place where you can have a nationalized US approach maybe you can extend into the EU, but really going around the world. And we're just talking about a few jurisdictions in here. We're seeing, countries in Africa have new laws. Brazil's got every place is going to have their own thing. And I think it's going to be really challenging to have a global approach, particularly where you have places that are a little bit more prescriptive about what they want. It's hard to kind of take a principled level approach and kind of level up to that. But
yeah, I agree with what you say, Jessica. And in fact, Michael, it's interesting what you say about companies sort of applying GDPR, because there's fundamental differences in the structure of the Australian privacy law and the GDPR. Particularly in Australia, we don't have a controller processor distinction. The law applies the same way to everyone. So in fact, and even as simple as our definition, our sort of foundational definition is personal information. But so there are key differences between the laws that can triple people up, and that's going to be increasingly the case with the further layers of complexity which are now being added to our relevant privacy laws. So I agree with what you're saying and with what Jessica's saying, which is there's a real tension because we're talking about a fully globalized industry with a localized set of laws. So there's a fundamental sort of misfit.
All right. Well, we've got time for one more question. And I'll put it like this. I would say that GDPR is our first scaled privacy law experiment that we've had in around the world. And there are invariably lessons to be learned, in particular as countries like Australia and plenty of others are in the process of amending their laws. If you could you've all spent some amount of time with the law in one facet or another. What has worked with GDPR? What hasn't worked from both a business and consumer standpoint? And if you've got some other great alternative, let us know what it is. And we've got 60 seconds to answer that.
So maybe I'll kick off as having done a lot of GDPR, Michael. I think what has worked, it has asked questions of companies, and those companies have spent time looking at their data, understanding what they do. And I think most businesses have looked at GDPR and improved their practices and improved what they've done in respect of individuals. What hasn't worked, it was so complicated and it's taken a long time to explain, and it'll take longer to explain. And my biggest fear is that they'll change it or amend it before we've really had time for it to bed down, whether that's because of enforcement or other pressures. But the complexity has been a real challenge.
All right, final words, Jessica.
I just want to add, and complexity coupled with vague terms,
of course,
don't even provide the protections that are intended, is a really bad combination.
All right, well, thank you all so much for this terrific discussion, and we'll turn it back over.
Right. This has been a great session, and I'd like to thank all of our speakers for just a tremendous session. So one of the things I'd just like to remind the audience, we have another session beginning right now, and that is on explaining AI, how to implement explainability in emerging global AI and ML regulations. So please join us, go into the portal and select that panel. Thank you.